Good morning, and welcome to the 7th Annual Relativity Fest Judicial Panel. My name's David Horrigan. I'm Relativity's Discovery Counsel and Legal Education Director, and it's my honor once again to moderate this panel of some of the most esteemed judges in data discovery. We've gone, frankly, around the world to bring you judges who can give you a diversity of thought, diversity of perspective from many different jurisdictions. My role here at Relativity is to bring something back to you, whether it's continuing legal education classes, blog posts on the Relativity blog, and making sure that we give something back to let you know and let you learn about the world of e-discovery and data discovery. Our first judge today will be the Honorable Joy Flowers Conti. Any of you who have attended e-discovery conferences in the last several years know Judge Conti. She is a fixture on the lecture circuit. She is United States Senior District Judge from the Western District of Pennsylvania. She served formerly as the Chief Judge of the Western District for several years. She brings a unique experience to our panel. Not only is she a jurist, she was, for many years, a practicing attorney, a leading woman advocate when she started her career, and of course, a former tenured law professor at Duquesne University School of Law. Judge Conti, welcome to the Judicial Panel.
Thank you. It's good to be with you all.
Our next jurist is the Honorable Tanya R. Kennedy. Justice Kennedy has recently changed roles. She was appointed by Governor Andrew Cuomo of New York in July of this summer as Associate Justice, Appellate Division of the New York State Supreme Court, First Judicial Department. She has a wide range of experience. In addition, she's got a little bit of academia. She was formerly an adjunct professor at Fordham. She is on the advisory board at Penn State Law, and she's the former president of the National Association of Women Judges. Please join me in welcoming Justice Kennedy. Justice Kennedy, welcome.
Thank you. It's good to be back.
Our next jurist is also someone who's been on the panel before, the Honorable William Matthewman, United States Magistrate Judge for the Southern District of Florida. Judge Matthewman brings experience not only as an attorney before coming to the bench, he's also a former police officer serving in Miami. He's also a little bit of a celebrity. All our judges are celebrities, of course, but if you check out 48 Hours or some of the mystery shows about real legal cases on television, you'll see a case by Judge Matthewman. Judge Matthewman, welcome back to the Judicial Panel.
Hello, good to see everybody and glad to be back.
Our next jurist is our international contributor, Master Victoria McCloud, Master of the Senior Court's Queen's Bench Division. She comes to us from the United Kingdom. She not only has judicial experience, she has academic experience, as our other judges do, but she has written extensively on the issues that, we're going to be facing today. Interestingly enough, something that should be interesting to our Relativity Fest audience, one of her publications is Suing in Cyberspace. In addition, she is working on academic pursuits at Oxford. And I want to point out a cultural note, if you'll give me a second. If you look at Master McCloud's photo, you'll see she's holding a book. That book is the first and oldest known publication in a book form of our United States Declaration of Independence. And of course, you're also going to see that it says honorable on there without a U. That is because, and I hope Master McCloud doesn't mind, we are using the anarchist colonial American English as opposed to the Queen's proper English. In the United States, we think all judges are honorable, and so we call all judges honorable. In the United Kingdom, you pretty much have to be a dame or a knight to have that title. But Master McCloud, you are here with us today, and I hope you don't mind if we break protocol. Please join us in welcoming the Honorable Victoria McCloud, Master of the Senior Courts. Master McCloud, welcome to Relativity Fest.
Thank you, David. It's good to be here.
And our final jurist is no stranger to anyone at Relativity Fest. The Honorable Xavier Rodriguez has joined me for all 7 judicial panels. He is someone who also brings, once again, a diversity of experience. Not only is he a federal judge serving as U.S. District Judge for the Western District of Texas, he's also been a state court judge. In fact, he served as Associate Justice on the Texas Supreme Court. In addition, he too has academic pursuits. He serves as adjunct professor at St. Mary's University School of Law, teaching e-discovery to the future e-discovery lawyers who are out there. Judge Rodriguez, welcome back to the Judicial Panel.
Thank you for the invitation. And where did you find that old photo?
All right, now we can look at the 5 cases we're going to be discussing, and you can see the topics that we have. We have discovery sanctions under federal law. We have discovery sanctions under state law. Justice Kennedy will take us there. Self-collection and e-discovery. This is a case Judge Rodriguez will be discussing, and we're going to have some thoughts on that as a minute because it's actually a case by Judge Matthewman, but because it's an active case, Judge Matthewman will not be commenting on that decision. We're then going to go into mobile data where Judge Matthewman will be talking about what can happen when we've got these new data sources. And then we'll wrap up with international law and data privacy with Master McCloud and the recent Schrems decision. Starting off with our sanctions under federal law, We Ride v. Wang. What made this case interesting is not only do you have auto-delete features, there's also an ephemeral messaging issue in this case as well. And you sort of wonder, what happens when you use ephemeral apps? What happens with how you set your email auto-deletion? And for that, we bring it to the courthouse steps. Judge Conti.
Very interesting case. The date of the decision is April 24, 2020 of this year. Just for knowledge of the parties, after the decision was reached and the order entered, the case settled shortly thereafter on May 8, 2020. And I'll talk about that just briefly. The takeaways from this case are, one, it is very important to have an order of court with respect to discovery matters. In this particular case, there was a preliminary injunction that was entered early in the case. The preliminary injunction required, among other things, that the data be preserved, that it be made available, that there be no destruction, and it also compelled certain kinds of discovery to occur, such as laptops being turned over, that kind of thing. So after the preliminary injunction was entered, various things continued to happen. One was an auto-delete function continued to operate. It was not turned off for several months after the preliminary injunction was entered. As we all know, you're not to destroy anything, and you must preserve all relevant data once you know that litigation is impending. And so the complaint was filed actually in November of 2018. Clearly, that's litigation. And there should have been preservation from that time on. But when the preliminary injunction was entered in February of 2019, there was an order. Once an order is entered under the federal rules, there are sanctions that come with it if a party fails to comply with the order. The sanctions under 37B are wide-ranging, and they can be draconian, meaning they can result in the ending of the litigation. These are called by the judge in the rewrite case as terminating sanctions. One takeaway with respect to the terminating sanctions, the judge ruled that the standard of proof is a preponderance of the evidence. You don't need clear and convincing evidence to terminate a case under Rule 37B. There were 5 factors that the court considered, and many other circuits around the country have similar kinds of factors that are considered when you're going to enter terminating sanctions. And they look at the public interest, the court's interest in managing a docket, prejudice to the party seeking sanctions, public policy favoring disposition of cases on the merits, and the availability of less drastic sanctions. When the court went through all of those, what struck me was a continued reference to the staggering amount of spoliation, massive spoliation, and the reference to massive scale destruction of data. And it happened in several ways. One, as I mentioned, was the continuation of the auto-delete function. When the former employee went to the new the new employer, there was a direction that they use ephemeral messaging. And so the question is, why did they use the ephemeral messaging? Also, the auto delete function was changed from a Microsoft default of 2 years to 90 days. So anything 90 days or older would automatically be deleted. The court ordered them to first try to restore or replace that data. And it was essentially a task that turned out to be probably expensive, but not productive because very little data was located. So essentially, there was great prejudice because of the volume of destruction that took place. In addition, the key players actually destroyed data by wiping devices. So devices were wiped. And another common feature that we often see in cases, companies have protocols that when an employee leaves, they take the devices and wipe the devices. There were 2 employees who left during the relevant time frame of the litigation, and the company, pursuant to its policy, took those devices and wiped them. They didn't change, in other words, policies that they had in place that would have been necessary to have a change to avoid this kind of destruction. So when the court looked at the overwhelming amount of data that was destroyed, looked at this different kind of conduct that went on, the court made the inference that all of this was done to avoid the turning over of this data. So the court awarded sanctions under Rule 37B, found all those factors were met. It also considered sanctions under 37E, and we're all, I think, familiar with that kind of standard where you have to see whether the data should have been preserved. Clearly, it should have been. It was lost because of a failure to take reasonable steps to preserve. And I think not turning off an auto delete, letting employees leave without changing your policy and preserving their data, that would not be reasonable under the standards that this court reviewed. And that data was not able to be restored or replaced. And then you have to find an intent to deprive. And the court here said quite clearly that you don't need to have direct evidence of an intent to deprive. All you need to do is to have a reasonable inference. So those are key takeaways from this case. The court didn't feel it was necessary to talk about inherent power because what it did was strike the answers of the defendants, and it also granted attorney's fees. And that's another sanction that comes under Rule 37B. You can have that solely as a sanction, or it can be in addition to. So they granted that additional sanction. When the case settled, the parties asked the court, and the court did vacate that preliminary injunction, vacated any need to pursue further sanctions, and each party paid their own fees and expenses.
Thank you, Judge Conti. It's certainly an interesting case, and one of the issues it brings up are the rule changes in the Federal Rules of Civil Procedure. Now, the 2015 e-discovery amendments are now almost 5 years old, and there was a big concern at the time among some that with the new standard of Rule 37E, that you had to show the intent to deprive, you had to make sure it couldn't come from another source, the multi-levels you had to take to get the most serious sanctions. This case appears to show us that judges have many other tools at their disposal to get at bad behavior in e-discovery. Judge Conti, what do you think? And I'd like to have Judge Rodriguez and Judge Matthewman jump in as well. Have you seen a lot of change in how sanctions are issued since those 2015 amendments?
I think, from my experience, judges were pretty cautious when first dealing with the rule changes. But as time has gone on, I think we've become more comfortable with how the rules function. And I am seeing more drastic sanctions being entered because judges now expect lawyers to actually take reasonable steps to preserve. And that standard is rising because it's an expectation that the lawyers will be experienced, and ethically they have to be experienced in these fields. And so judges, I think, are a little leery when they see cases like We Ride, where there is unexplained conduct that is repeated over and over again. And it's a totality of the circumstances that will result in the sanctions being imposed. So I think there's a greater receptivity by the courts in the appropriate cases to actually enter the terminating sanctions.
Thanks, Judge. Judge Rodriguez, your take on sanctions.
So Rule 37E has been very effective in changing the culture of issuing sanctions for negligence. And so I think the message has been received loud and clear from the judiciary. Negligent spoliation doesn't lead to terminating sanctions. So the rule's been effective for that. But I think as this case, and as Judge Conti thoroughly outlined in this fact scenario, intent to deprive, we never generally get in intent cases direct evidence. It's always circumstantial. And here, the amount of circumstantial and perhaps even direct evidence just was overwhelming in the totality of the circumstances case. And so it was very easy, I think, to issue terminating sanctions in the We Ride case. But, I'm more concerned about just ephemeral messaging in general. Unless companies can start establishing a business need for using these types of apps, I'm very concerned about where this is going to lead in terms of spoliation of evidence. We're already seeing cases where law enforcement officials have gone to using ephemeral messaging to circumvent what's taken place. We've seen government officials in efforts to circumvent open meeting acts going to these platforms. I've actually had arguments on other panels where someone has told me this is not ESI. It is ESI, and depending upon which app you're using, you can keep these. You can keep the data. It's not always so ephemeral that it's automatically deleted. Now, some of these apps are, but if you have control of the settings, you need to retain these communications. And ephemeral apps are going to be quite concerning, I think, for the courts, and we'll see where this leads us.
Thanks, Judge. Judge Matthewman.
Yes, I agree with both Judge Conti and Judge Rodriguez. And it's interesting because I had a similar experience to Judge Conti. I had a recent case where there were three, it's closed now, there were three individual defendants, all of whom, for some reason, could only produce favorable texts. And it dealt with a similar fact pattern as in We Ride. And one said that his cell phone had been dropped in the lake and run over by his truck and was gone. The other one said that he had sold his or traded in his cell phone and bought a new one, but nothing got transferred over. And then the third one said that I bought a new phone and I think I transferred everything over, but this is all we have. And the other side was saying, no, though there's a lot more text messages out there. So in thinking about it, the first thing I was going to do is authorize a subpoena to the carriers to get those text messages. But then I realized that they only hold them for a very, very short period of time, and that would have been fruitless. So what I did was I set an evidentiary hearing. I advised all three defendants they were going to have to testify about what happened to their phones and whether they had backup systems, whether they had Apple storage or any other cloud storage. They were going to have, I appointed an expert that they were going to have to pay initially. Once the plaintiffs pay half and the defendants pay half, and then I would apportion it later. I set down an evidentiary hearing, and I said that the expert would be allowed to look at the current phones and any backup systems to see if the expert could retrieve the text messages that were allegedly spoliated. And so the hearing was set. The expert I ordered an expert appointed. And I think that I set the hearing out maybe 3 or 4 weeks. And quite surprisingly, I guess, just maybe a week or so before the evidentiary hearing, the case completely settled. And they asked that the order be vacated. and the case closed completely. So I think Rule 37E has been good. I think it helps judges know how to handle these spoliation issues. And I think there are a lot of ways to get at these spoliation concerns, because our concern is we want all the evidence to be presented that's relevant and proportional, and we don't want any party to be able to destroy or get rid of evidence, because that skews the justice system. And so I think that this case and others have shown that I think Rule 37E has been a good amendment under the rules.
Thank you very much, Judge. Now, of course, we talk about federal courts a lot. A lot of litigation occurs there. However, the vast majority of litigation actually occurs in state courts. And that is why we are glad we have Justice Kennedy with us here today. Here is an interesting case, and to say the fact pattern is somewhat unusual would be an understatement. If any of you are familiar with the Redken hairline, its co-founder was Paula Kent Meehan. Sadly, she passed away in 2014 after a very rich and full life, and her estate was valued at over $100 million. Her son, Michael Miller, was one of the beneficiaries of the estate. He got about $13 million, but he wasn't happy about that. One of the reasons was because the vast bulk of the estate went to a charity that Ms. Meehan had founded, the Pet Care Foundation, and thus litigation ensues. The fact pattern is very interesting because, of course, we get into an issue of bad behavior. We have an appellate brief that perhaps might have been written differently. We even have counsel getting into a fight in a sushi restaurant with Sharon Osbourne, famed for Ozzy and Sharon Osbourne, for, about alleged cheating in a birthday party charity contest. So you've got the bulk of the corpus going to the dogs, as many of us think maybe it should. You've got sushi fights. You've got interesting appellate briefs. Justice Kennedy, you've recently ascended to the appellate bench. Your take on this case?
Sure, David. I just want to briefly highlight just some of the attorney's conduct. The attorney repeatedly failed to respond to discovery requests, made misstatements to the court, as well as repeatedly failed to provide a privilege law with the required information in accordance with the law. And certainly the trial court imposed $5,000 sanction on both the son and the attorney. And it was based upon a particular state statute that authorizes a court to exercise its discretion to impose monetary sanctions for discovery abuses. And certainly when it went to the appellate court, the court indicated that the trial court did not abuse its discretion, that the court properly exercised its discretion in imposing sanctions. I want to put my trial hat on and say that I believe that this conduct would also be sanctionable under our state's statute, Rule 3126, and it gives a judge wide latitude. And certainly now pulling my appellate court hat on, certainly the standard of review once again is abuse of discretion. Did the court properly exercise its discretion? And I believe that an appropriate record was set by the trial court, laying out the repeated failures to comply with discovery, the repeated misstatements to the court, let me say knowing misstatements to the court, as well as the repeated failure to provide a privilege law. It was very basic, didn't have any of the required information. But David, when I read this case, there was something else that came to mind. When an attorney comes before the court, credibility is everything. And in Miller, this attorney cited the law, cited statutory provisions that were no longer in effect, really made disparaging comments about the court and counsel, and also made frivolous arguments. And, let me just say, David, that, and I said this at Penn State when I spoke for the commencement address, that having an education and certainly a law degree, it's a privilege. It's an asset. You have to nurture it. You have to protect it. And that we are required to maintain the highest ethical standards and also abide by the applicable rules of conduct. So my takeaway is that you must comply with discovery. Oh, and let me say also that the attorney also failed to comply with the rules of the court. Any attorney should know the applicable rules of the court. Certainly, the applicable law was not adhered to in this case. The bottom line is you have to be above board when you come before court, have the necessary decorum and respect, not only for the court, but for opposing counsel and the parties, and to know and state the relevant law, state and know the relevant rules of the court, and comply with discovery. But certainly when sanctions are imposed and the court sets forth its reasoning, the sanction will be upheld. And that's certainly my takeaway.
Thank you, Justice Kennedy. Now, we've heard about federal law in the United States from all of our federal judges. We've heard about state law sanctions from Justice Kennedy. I'd like to take a trip across the pond and ask Master McCloud, how might sanctions be handled in the courts of England and Wales?
Well, thanks, David. I mean, I've been sitting here thinking how nice it is to find that things are pretty much the same on both sides of the pond. I just want to echo from the position of a judge over here what was just said in terms of the importance of advocates and being able to trust them. We have a rule, for example, that if an advocate appears in court and is aware of an authority that is against them on a point, they can't mislead the court by failing to mention that if their opponent, for example, happens to be unaware of it. It's very important that we can trust what we are told. And of course, reputation is everything, because so often we take for granted what an advocate tells us, and we need to be able to rely on it. Otherwise, we would be spending so much longer in court, having had to have everything documented, everything sworn in, stamp or whatever. We need to be able to trust the people who come between us, if you like, in the cases that they're presenting. But what I found very interesting with what was being said, and thinking about the rule changes that you had in 2015, is how similar your reworded Rule 1 is to what we have in our Rule 1, which is the overriding objective. And I've got your Rule 1 on the screen over there, and it talks in terms of the parties and the courts to construe, administer, and employ the rules in a manner to secure the just, speedy, and inexpensive determination of every action, etc. Our wording, which has been pretty much the same since it came into force in April 2000, has the overriding objective. It says, dealing with the overriding objective of the court rules, and these are national rules, applicable in England and Wales, which is my jurisdiction. Scotland is a different legal jurisdiction. These rules are a procedural code with the overriding objective of enabling the court to deal with cases justly and at proportionate cost. And dealing with a case justly and at proportionate cost includes, among other things, saving expense, dealing with cases proportionately, taking into account the financial position of the parties, making use of an appropriate share of the court's resources, because we have many litigants in the system and parties who waste time enforcing compliance with rules, practice, directions, and orders. So it's the parties and the courts and the representatives' duties to make sure that cases are advanced in that way, so as not to waste court resources and so as to ensure compliance with court orders. And I was really struck at the similarities between the approaches taken in both of the cases we've heard about and the approach that would be taken here. We don't have a very strict formulation of what to do. There's a case called Mitchell that I first instance decision in, and the appeal court thankfully agreed with me, a rare event, in which the approach in that case, and then later clarified, was that you look at how serious the breach is, whether there's a good explanation. And I'm afraid all too often one hears things like, well, I had a laptop, it was stolen, and I never backed anything up ever in my entire life. So everything was on that laptop, it's gone, or I sold my mobile to someone down the pub or whatever. And if there is a good explanation, well, depending on the impact, you may allow matters to proceed. And you look at all the circumstances. How prejudicial is it? And importantly, of course, can it be remedied? And you can impose sanctions, and they can be sanctions which could terminate the case, or could involve the payment of legal costs, or, of course, for example, footing the bill of forensic experts to deal with retrieving lost disclosure or fixing the error. So it's really a very similar approach, and it's an increasingly strict one here as a matter of policy because there are limited resources and too many litigants for those resources.
Thank you very much, Judge. Appreciate that. We are now going on, and Master McCloud has given us some perspective from across the pond, and we're going to get into another issue that is going to affect us all, and we've touched on it a little bit, and that is the area of self-collection, because we've talked about ephemeral data, we've talked about some of these other issues. As I noted at the top, this case that we're going to be discussing is a case that Judge Matthewman is presiding over. Judge Matthewman is the author of this decision, so he will not be commenting on this, and I'll turn it over to Judge Rodriguez.
So I'm going to be a little contrarian here, but, I think Judge Matthewman absolutely recited all the previous cases correct. But, I have some questions. So this was an age discrimination case. And the judge referenced this case as perhaps complex. I'm not sure why. I don't see that on the basis of this order here. It's only a 5-page order that we're working off of. So I'm sure the case was complex, but it seems to me that it was just a one plaintiff case. It didn't involve like a reduction in force or something that a lot of documents and evidence would be required. And it's, as you mentioned, it's a smaller grocery chain. And so I think all those are factors to take into account as to ultimately what takes place here. It appears from this order that a set of documents initially were provided, and how much was initially provided is uncertain from this order. But at issue before the court was two things. One, a more complete answer to an interrogatory and a more complete response to a request for production. So I think we stop here for point one. Is normally if there's an allegation that there was a deficiency in the document production, normally we require the requesting party to show some prima facie evidence that the document production was deficient, or we order any kind of discovery on discovery, which is what basically the EEOC wanted. They felt that some other documents must be in existence, and so they wanted to go towards a review of the computer systems. And so I'm a little concerned that we didn't talk about that issue first, about what was so deficient about the production. Then the second point that's very interesting about this case, I think, is the client, in response to the argument here about was deficiency in the production, makes the acknowledgement, the attorney makes the acknowledgement that she relied or he relied on the client to gather the documents. And so Judge Matthewman becomes concerned at this point that we've relied on self-collection. So there's a recitation of Rule 26G, which requires a certification by the lawyer that to the person's knowledge, information, and belief formed after a reasonable inquiry that it was complete and correct. And so Judge Merriman, I think citing a lot of pre-2015 and Judge Schindlin statements, says, how can a lawyer certify under 26G when he or she has just relied on the client to do all the document discovery, which is a reasonable, I think, question to be asking. But now, in light of 2015, do we take proportionality into account? It's, I think, a relatively small, simple case with a smaller client at issue. So does it become completely unreasonable at this point to require or prohibit, rather, self-collection by that client? I think I would have liked to ask the question, what made you believe, or why should the lawyer had reason to believe the production was deficient and start questioning what the client did? There was some amount of documents that were previously discovered. Now, let's go back to old paper world. So when I did employment law cases back in Stone Age, we would ask the client, hey, I got an employment case. Thank you for hiring me. I need the employment file, the payroll file. Let's talk to the manager to see whether they had their own little version of the personnel file. And I would get some folders, and I would have a basis to say, I think something else is missing here. Can you check? So I think a lawyer does have that duty to start making those inquiries about, it appears that documents are deficient here, but we didn't get a lot of that in this order here about just exactly why the lawyer should have been put on notice of a deficiency. In light of 2015 rule changes and proportionality, I think maybe the game has changed. And the game, I think, has certainly changed on the ground. In-house lawyers now have taken control of the discovery process to a very large extent. And so outside counsel many times are completely excluded from the process. And so basically in-house counsel from big box and other major retailers are saying, you tell me what, you forward to me the request for production, we will gather all the documents, we will send them to you, and we're not paying you to do anything further with regard to this process. And so we have a real tension, I think, being built from what's being done on the ground versus a lot of these 2015 cases that seem to suggest that self-collection may be completely inappropriate. I will concede this and I'll stop. It is completely inappropriate in some cases. I think it's completely unreasonable to allow the individual accused of perhaps sexual harassment or race discrimination to do their own self-collection. I think it's completely unreasonable in an antitrust case for the CFO and the CEO to do their own self-collection. But in other cases like this, it becomes, I think, a little more up for debate out there.
You know, I'm about to do something that no lawyer should ever do, and that is try to speak for one federal judge and almost get into a debate with a sitting federal judge. But I'm going to go out on a limb. Judge Rodriguez, I hope you don't mind if I play devil's advocate, only because, as we said at the top, Judge Matthewman can't discuss this case. This would be great programming if it were a regular Relativity Fest where we could go back and forth on it, but we can't. So if you don't mind, if I could ask you, Judge Rodriguez, is there something wrong with making it black letter law that you can't be collecting your own data? Think back to when we were kids and the teacher wasn't going to grade the papers. You pass your paper to the kid next door. He grades yours. You grade him. No one is doing self-grading, and nobody should be doing self-collection. Just playing devil's advocate. We've had Bird v. Ford Motor Company. The courts have said it's a bad idea. What about, instead of, as you say, make it case-by-case basis, what about just making it black letter law? You can't self-collect data. Judge, I will face your wrath now.
So, I appreciate that. And like I said, I think there's going to be some cases where it's completely unreasonable. But going to Master McCloud's earlier statement about just, speedy, and inexpensive determination of every case, I think at some point, some low-level monetary cases, I think we're defeating the purposes of inexpensive on requiring an expert to come in or a forensic investigator to come in or someone an outside consultant to gather all the evidence in those low-level cases. That's where I can think the proportionality analysis starts to come into play.
All right. Thank you, Judge. Appreciate that. We are now moving on to a case where Judge Matthewman actually can talk. And it goes into a lot of his experience as a former police officer, as someone who's done a lot of forensic work and who has written extensively on these issues. Judge Matthewman, we talked about mobile data a little bit earlier. In this case, there was the issue of Mr. Morgan's iPhone in the United States v. Morgan. It's a criminal prosecution, and it raises some of the issues that you've brought up. In this case, Apple gives you the option of a 6-digit passcode as opposed to the thumbprint or as opposed to the 4-digit passcode. And many technologies, our partners at Celebrite can do this, can crack phones, and you've seen it in other cases. But what happens here is the Apple comes with a feature that if you have so many bad attempts, it freezes the phone. The end result of this, brute force on this one, it would have taken law enforcement 37 years to crack this phone. So then defendant comes in and says, hey, I want my phone back. What about my interest in this? Judge Matthewman, your take on this one.
Well, this is United States versus Morgan, and it's a really fine, well-written and interesting opinion by Judge Wolford from the Western District of New York. And the site is 443 Fed Sup 3rd 405, and it's March 6th of 2020. So in this case, the defendant was charged or is charged with bank fraud, money laundering, wire fraud, those types of charges, and is pending trial. And filed a pretrial motion saying, in effect, that the government seized my iPhone and they've had it too long and it has my personal information on it and I want it returned under Rule 41, which is a federal rule of criminal procedure. So the phone was seized May of 2018. And the defendant's motion was filed January of 2020, more than a year and a half later. The case is still pending trial. So as many of you know, I'm sure all of you do, iPhones can be protected by a password. And in this case, the phone was protected by a 6-digit passcode. But when the phone was seized, along with a lot of other electronic evidence, and pursuant to a properly issued search warrant, the government agents asked the defendant, at that time he was not a defendant, a suspect at that time, asked that person to tell them the passcode, and he declined. So the government started using a device called Gray Key, which enters passcodes serially to unlock the phone. It's a very slow process. They can only do 2 or 3 attempts per hour. And a 6-digit passcode yields approximately 1 million potential combinations, 1 million potential passcodes. And as of January of 2020, some 960,000 possible passcodes remained, despite using this process. So the defendant says, I want my phone back, you've had it too long. The court ruled, and I think properly, that the iPhone was properly seized pursuant to a search warrant supported by probable cause, and that the government's interest in the iPhone, at that time it was 1 year before trial, outweighed the defendant's interest in its return. So the defendant's motion for return of the iPhone was denied, and the government was free to continue its Herculean effort to figure out the passcode. So, as I said, I agree with Judge Wolford. The opinion's well written and correctly analyzes the law and Rule 41 as to why the pretrial motion should be denied. But I think the undercurrent raises a really significant, important issue that a lot of people may not realize. Some people secure the contents of their phone, iPhone, or whatever with a numerical passcode, like in this case. Others use biometrics, a fingerprint, a face, whatever it may be. So I would ask, which do you think provides greater security? Probably those folks who use biometrics and are more techie and may think that biometrics provide greater security. However, from a criminal law point of view, that might be inaccurate. Because, for example, in my circuit, in the 11th Circuit, the law is clear that a suspect's act of uttering a passcode to a phone or a device is testimonial and cannot be compelled by the government. So a defendant or a suspect can't be ordered to say, my passcode is whatever. What about biometrics? The courts are looking at that differently. And many courts, and it still is an issue in flux, but many courts have come to the conclusion that compelling biometrics is not testimonial. It's more like DNA. It's more like fingerprints. It's more like standing in a lineup. And therefore, courts have ordered that a defendant's finger can be placed on a phone, or the phone can be placed in front of a defendant's face or a suspect's face, because that is not testimonial. So there you have the situation where it very well may be that a government can force you to put your finger on the phone or your face and compel biometrically opening the phone, but cannot force a person to testimonially, in a testamentary manner, state what the passcode is. So it's a really interesting issue where it very well may be that people who want to provide extra security of their phone by biometrics might actually have less security than a passcode.
This case is the case of what's commonly called Schrems 2. Master McCloud, there are many, many variables that are going into this equation. We have new types of data. We've got ephemeral data. It really wraps up a lot of the issues we've discussed today. And of course, dare I say it, Brexit could be an issue too. Master McCloud, your take on this one?
Thanks very much. Well, to start with, I should say this, of course, is a very lengthy decision. You only have to look at the composition of the Grand Chamber of the European Court of Justice to appreciate how it ends up being 47 pages long with very long recitals. And of course, the law of state surveillance and privacy can be pretty complex, especially when you're talking about cross-border transfers of data. And we all know that post 9/11, there was an increase in the sharing of data, but then perhaps there was a bit of a backlash, a bit of a tightening of, certainly within the EU, the data protection and privacy laws. And as David has correctly said, in order to implement data protection rights and privacy in the EU, when it came to US transfers of data to the US, the safe harbor framework was put into place. Now, I needn't go too far into that, safe to say that it involved self-certification by the exchanging parties. And that is a pretty weak protection if you simply have to say self-certify that you're complying with European data protection arrangements. Now, before I get to the privacy shield, which is what has just been abolished by Schrems 2, I should probably spell out for anyone who isn't familiar with the way things work within the European Union, that the Commission, European Commission, is effectively the executive within Europe. It proposes laws and it can make executive decisions. So you might hear it's a decision of the Commission. That's not a judicial decision, it's an executive decision, and it can be challenged in the courts, just as similar things could happen directly in the UK or in the US. The court is the European Court of Justice, the CJEU, which is effectively the Supreme Court. And it's the CJEU that has overturned the Commission's decision to declare, in this instance, the privacy shield adequate. Now, what was the privacy shield? Well, when the safe harbor framework was declared inadequate, parties began making use of standard contractual clauses to a greater degree than they had before, so as to regulate as between themselves what the user's rights were. So if you were a user, there would be standard clauses governing your rights to privacy. But alongside that, there was obviously a need to ensure that if data is transferred to the US, those clauses are in some sense going to have teeth. There's not a lot of point having contractual clauses if you can't in practice rely on them. And what the Commission did, and here I think it highlights perhaps a difference in outlook between the executive and the court, perhaps the outlook being more in favour of free trade and commerce and wanting to make things flow. What the Commission did was obtain assurances from the US, examine what the rules and laws were in the US, and importantly, extract an agreement from the US that there would be an ombudsperson appointed to handle privacy matters. And based on that, they declared that arrangement to be the privacy shield. And if you have the standard contractual clauses and the privacy shield together, that was regarded as sufficient to permit data transfers of personal data from the EU to the US. Mr. Schrems wasn't happy with that, so he took Schrems 2. And it's Schrems 2 that was decided recently, as I say, invalidating the privacy shield. Quite simply, what the court decided was that the teeth were not sharp enough. So we have this bombshell that rolled off the judicial bombshell production line at the CJEU, setting all that aside. But importantly, what they did was they said, well, standard contractual clauses are fine. You can have those, but that isn't good enough on its own. There's got to be some arrangement so that the parties are satisfied and the user can be satisfied and the court can be satisfied that those clauses can be relied upon and that the rights they provide are practical and effective. And what that means is if you've got standard contractual clauses, you've got to look at the jurisdiction you're moving the data to and establish whether those clauses, in fact, will provide the necessary degree of protection. And it follows really from Schrems 2 that for transfers to the US, no, that wouldn't be the case at the moment. So parties are going to have to consider what they're going to do. Can that be resolved by having tighter contractual clauses in some sense? That's a very live issue, and this decision was only given in July of this year. And of course, in the midst of COVID as well, that's quite a bombshell to happen just at that time too. So what's the meaning of Schrems 2? Well, I think the actual worth of standard clauses really has to be seen in the context of whether they can be enforced. Is it going to provide practical and effective rights? That's now going to be quite a heavy burden on data exporters to satisfy themselves, particularly in the case of the US, that those clauses can remain adequate, even if tightened up. So what could one do? Well, as a bare minimum, the court suggested that there should be an obligation, at least to inform, an obligation on the data importer to advise the data exporter if at any stage it becomes unable to rely on those clauses. If something's occurred or a law has taken place or the government has been in touch or whatever, so that there is effectively a threatened or actual breach pending of those clauses, and then a converse obligation on the data exporter, let's say Facebook UK or Facebook Ireland, it would be, not the UK, to then cease exporting. But that doesn't necessarily solve the problem, because you can easily imagine a state law that says, well, you're not allowed to tell the opposite number. It could override contractual law. That's always going to be a risk. So one then has to consider more technologically based potential solutions. For example, to have data that goes to servers not within any accessible range of the US, perhaps on foreign soil, with just limited proportionate transfers of data as and when needed into the US. Or perhaps that in the future, the US may have to consider, or the companies may have to consider, some form of licensing arrangement whereby the US state agrees that the safeguards in place within a US company so that the US state will be informed of criminal activity and will have proportionate access are sufficient to enable that company to be trusted and not snooped upon and not imposed upon. So some sort of vetting and licensing system, because the EU system doesn't say the state can't see data. What the EU system says is access has to be proportionate, and there have to be judicial and legal safeguards that are binding in order to protect the citizen from the state as part of the balancing process. So it's not about locking data up entirely with the 6-digit passcode. It is about having a framework whereby users can know that if the state does access data, it's only doing so in a proportionate and measured way. Another potential technical solution could be, for example, encryption, and this is where the mobile phone case is interesting. You could have holographic encryption, whereby you have parts of the data which are necessary encrypted in one jurisdiction, which adheres to EU safeguards, and other parts, perhaps within the EU, and you can't access or piece the data together unless you bring the two together. So it's a sort of multiple key holder system. Interestingly, what the court said in Schrems, a little off not observed footnote, as it were, is that they also held that data transfers along undersea cables were of concern, because the laws permitting the US state to tap into those cables to access data actually rendered them not in compliance with EU data standards. So it wouldn't necessarily be advisable even to transfer data offshore to a third-party country for holding, if along the way those cables could be accessed. So it raises a lot of questions which have nowhere near been answered yet, and the undersea cable point is actually potentially a very important one. But is there an digital elephant, if you like, in the Schrems panic room? Perhaps there is. Perhaps the obvious solution would be for the affected commercial bodies to consider whether the US could be persuaded to move towards an independent regulatory body of a quasi or actually judicial nature, which has powers binding on the US state, so as to adjudicate on alleged infringements of rights, or the proportionality and reasonableness of proposed mechanisms of access or proposed bulk interception or whatever. If necessary, of course, such bodies can sit in secrecy if one's talking about terrorism operations and so on. So I think the message from Schrems is it's not over yet. There may well have to be a Schrems 3, and there's certainly going to have to be a big effort by the member states and by the US to consider, well, what now? Because perhaps either the EU may have to move, or the US may have to move in terms of the stance taken in terms of balancing citizens and state rights. Now, what about Brexit? Well, that's due in just I don't know, about 4 months or something. In terms of the final departure of the UK, that raises the possibility of gradual evolution of different rules here from those in the US, and questions about whether we'll have a sort of UK version of Schrems, whether we'll be in compliance with the EU law, whether we'll have something in between, or what will happen. It potentially adds just that extra layer of complexity, especially given that a lot of data actually passes through undersea cables into the west of England and comes ashore at the beaches of Cornwall and other places, entering parts of Europe that way. So that whole infrastructure needs to be considered from both a legal and a technical point of view. So it's a fascinating and very complex case, and it's not over yet, I think.
Master McCloud, thank you for that in-depth analysis of Schrems, and of course, reminding us that there are always options for transferring data. Data know no international boundaries. The safe harbor may have been invalidated. The privacy shield may now have been invalidated as well. Standard contractual clauses still around. We'll see how that works out. But the parties have always found a way to allow data to cross international borders, allow business to continue while respecting data privacy. So thank you for that reminder. Now moving on. We're running very tight on time, and our attendees need to get to the next session. But as always, I want to give you an opportunity to say just a final remark. Sadly, it's going to have to be a lightning round, 30 seconds each. Starting with Judge Conti, your biggest takeaway in 30 seconds, please.
Okay, I agree with Judge Matthewman, and I think Judge Rodriguez also agreed that there should be no self-collection if the party doing the collecting is an interested party. Under those circumstances, there needs to be dialogue between the counsel and the court. This is where you have to have transparency. And if there's a proportionality issue, then the court should investigate having the burden shifted to finance the investigation by an independent party to the party doing the requesting. So I think there are some other tools we have available to avoid the problems with self-collecting, and it doesn't have to be a situation that results in very severe sanctions.
Thank you very much, Your Honor. Justice Kennedy, your 30-second lightning round conclusion.
I also want to go back to Judge Matthewman's case. I had raised my hand. I wanted to add something. There's not a state statute, but I saw another issue here, particularly with ESI. You know, the ABA model rules indicate, Rule 1.1, that lawyers must understand the benefits and risk of technology. So I also shared my colleagues' concerns when it related to ESI. And also Rules 5.2 and 5.3. You have the duty to supervise. You have to keep that in mind when we're undergoing discovery for ESI.
Judge Rodriguez, your lightning round conclusion. Thank you, Justice Kennedy.
I'll try to tackle the cross-border issue. So I'm not sure where Schrems is going to fit on civil cases that I think are going to be of interest to our audience. Schrems was concerned with the ability of the U.S. government to access data. Now, I don't think it's a far stretch to say that we're going to hear Schrems now in cross-border disputes in civil cases here in the United States, where a piece of litigation here is trying to access data that's relevant and proportional. So we're probably going to see Schrems extended as another argument why the producing party should not have to produce documents overseas. Real complex area of law. I think aerospatial factors are still going to apply here, and whether the American courts are going to still give some more deference to the Europeans in cases. I think we're going to have to do an analysis of proportionality and an analysis of what fines the producing party may face. This is going to be an interesting show in a couple of years.
Thank you, Judge Rodriguez. Judge Matthewman.
Yes, Justice Kennedy talked about the discovery sanctions, and everybody really spoke about ethics and professionalisms of lawyers. And the way I see it is we hope that the lawyers acting ethically and professionally will produce all the discovery that they are supposed to, everything that's relevant and proportional. And we hope that that gets to be the message to the entire bar. However, for that portion of the bar who doesn't listen to that or doesn't comply with that, then we have the issue of sanctions like Justice Kennedy talked about. And in federal court under Rule 37, those can apply. To me, they're a last resort. I don't like issuing sanctions, but they are necessary when lawyers and parties aren't necessarily complying with their discovery duties.
And our final word from our guest from the United Kingdom. Your final word, Master McCloud.
Very brief, rapid fire bullet points. Court needs to be able to trust advocates. I think we've all agreed on that. The duty to supervise disclosure may be flexible, but it doesn't sound like it should be ever abandoned. We need to be able to rely on disclosure and not pure self-collection. The word proportionate keeps arising. In all of these cases, notions of proportionality has arisen. Sanctions, how you manage cases, to what extent you interfere with privacy, and to what extent retaining property is proportionate or not. So I think the word proportionate is going to keep on falling from our lips for some time to come. And lastly, sanctions need to be practical and effective in order to ensure that court resources, whether here or on your side of the Atlantic, aren't squandered, because there are only ever a finite number of courts, finite number of judges, finite number of lawyers, and we mustn't crowd people out by having cases that occupy more than their due share of resources if people are playing games, breaking the rules.
Thank you, Master McCloud. We'll see you next year.
Thanks. Bye-bye.
Thank you.
Bye-bye. Stay safe.